effect that the final 10 minutes of debate be equally divided between the chairman and ranking member of the Judiciary Committee or their designees, with the chairman controlling the final 5 minutes. Further, that there be 4 minutes equally divided between proponents and opponents prior to each vote.
Is there objection? Without objection, so ordered.
And, Madam President, I reserve the balance of the time for Senator Cantwell.
Without objection.
Thank you.
Madam President.
Senator from Texas.
Madam President, may I inquire of the Chair how much time remains for me to speak before we get into the last order from the Chair?
4.5 minutes.
Madam President, I want to speak a minute for just 4.5 minutes, I guess, about the natural disasters that have been confronting our nation, and in particular in Texas, where the state has had about 3.5 million acres of land burned, and many people now find themselves literally homeless as a result of fires that many of my colleagues have seen on TV or watched on the Internet, but they frankly don't capture the scale of the devastation. Just to give you an idea of the scope of this natural disaster, so far in 2011, more than 18,000 wildfires have been reported in the state. As I mentioned, it's burned an area roughly the size of Connecticut. And nearly 2,900 structures have been lost, and unfortunately there's also been a loss of life in these fires, as well as 5,000 Texans now have been evacuated from their homes. And unfortunately, these fires have been a feature of life in parts of Texas for most of the year because we are in the middle of a historic drought, where because of La Nina, the weather pattern, we have an abnormally dry year, and indeed it's caused more than $5 billion of agricultural losses alone as a result of that drought. I've not only seen some of the devastation myself before I left Austin, but I've also talked to a number of people on the ground who are well informed. Representative Tim Kleinschmidt, who represents the Texas district east of Austin in sort of the Bastrop area, told me that as many as 1,000 people have been evacuated from his homes in that area and have been living in shelters since Sunday. Water and electricity are also down in many areas, and the wind has unfortunately swept the fire into areas and now is only about 30% contained. I've also talked to some of our other local leaders, our county judges, like Grimes County Judge Betty Shiflett, who told me while they have no unmet needs right now, they are very concerned about the threat to life and property and are working as hard as they can to contain the fires. I've also talked to our outstanding chief of the Texas Department of Emergency Management and the director of the Texas Forest Service, who tells me that as many as 2,000 Americans from places other than Texas have come to the state to help fight these fires and help protect property and life. We've had a good federal response to one extent, and that is the U.S. Forest Service has provided planes, bulldozers, and other equipment. Unfortunately, we have seen the White House so far not extend the disaster declaration beyond the original 52 counties approved for FEMA assistance on May the 3rd. Or I should say that assistance ran out on May the 3rd more than 4 months ago. Suffice it to say that the disaster declaration should be extended to cover the rest of the state, at least 200 more Texas counties that need federal assistance. I'm informed from reading the newspaper that President Obama reached out to Governor Perry yesterday to extend his condolences, but frankly, more than condolences, what we need are the resources to help fight these fires, to deal with the disaster, and to help get people back in their homes as soon as possible. I would just say that in conclusion, Madam President, that the Majority Leader has raised the question of whether disaster relief should be paid for or whether it should be borrowed money. I come down on the side of believing that we can't keep borrowing money we don't have. That's what the American people keep telling us. That's what the last election was all about. That's what the financial markets are telling us. And I believe that the American people believe that we have plenty of money in the federal government for Congress to do its job. by setting priorities and funding those priorities. And I believe that emergency assistance to the people who've been hit hardest by these natural disasters are one of those priorities. We should fund it instead of funding wasteful spending and duplicative programs and engaging in failed Keynesian stimulus schemes. So, Madam President, with that, I yield the floor.
Senator from Iowa has 5 minutes.
Thank you very much. I urge my colleagues to oppose all 3 amendments to the patent bill so that we can send this important jobs bill to the President of the United States for his signature. I urge my colleagues then to support final passage of Leahy-Smith America Invents Act. This is a strong bipartisan bill that will enhance America's innovation and give us economic growth. It will protect inventors' rights and improve transparency and third-party participation in the patent review process. It will strengthen patent quality and reduce cost, and will curb litigation abuses and improve certainty for investors and innovators. The Leahy-Smith America Invents Act will also help small entities in their patent applications and provide for reduced fees for micro-entities and small businesses. It will help companies do business more efficiently, both here and abroad. The bill includes a provision that will prevent patents from being issued on claims of tax strategies. These strategies can add unwarranted fees on taxpayers for attempting to comply with the tax code. Finally, the bill will enhance the operations of the Patent and Trademark Office with administrative reforms, give the Patent and Trade Office fee-setting authority, which we hope then will lead to a reduction of backlog and improve the ability of the Patent Trademark Office to manage its affairs. I want to thank Chairman Leahy, Senator Hatch, the lead sponsors of this legislation, for the tremendous amount of work that they put into this American Invent Act, not only for this Congress, but over the past 3 or 4 years that this bill's been worked on. This has been a long process spanning those several Congresses, and without the leadership of these 2 senators on patent reform, we wouldn't be ready to cross the finish line today. In addition, I want to thank the staff of the Judiciary Committee, Bruce Cohen, Aaron Cooper, Curtis Legite, of the Chairman Leahy staff, Matt Sandgren of Senator Hatch's staff, Joe Mattel of Senator Kyle's staff, and I'd like to thank the floor staff for their help in processing this bill in an efficient manner, and I'd like to especially thank Colin Davis and Rita Lara Yoakum of my staff for their hard work on the bill. So, for a 3rd time, I urge my colleagues to vote for the Leahy-Smith America Invents Act and to oppose all the 3 amendments we're going to be voting on so that we can keep the bill clean and send it to the President without delay. Senator Leahy has made it very clear to all 100 senators that if you support this bill, it is a gamble to say that it will be law if we have to move it beyond the Senate to the House. This bill will help American inventors create innovative new products and services and stimulate job creation. The bill will upgrade and strengthen our patent system and keep America competitive in an increasingly global economy. This is a good bill. I urge my staff, all of my colleagues to support it. How much time do I have left, Madam President?
1 minute.
I would urge my colleagues, because I rebut the Senator Sessions amendment, to keep in mind that when somebody tells you that this is to bail out one company, understand that that one company has gotten justice from the judicial branch of our government, because a judge has said for that company that they were denied their rights under the 60-day rule to file for an extension of patent. So what that judge said was that bureaucrats in our agencies acted in an arbitrary and capricious manner by not having the same rules that designate when the 60-day period of time starts. So we have a judge that says so, so maybe people can refer to that opinion and get what you want. But we ought to have it in the statute of what's uniform. And that's what the bill does, and the Session amendment would strike that. I yield the floor.
Senator from Vermont has the balance of the time until 4 p.m.
Thank you, Madam President. I thank the distinguished senator from Iowa for his strong support of this bill. You know, in a few moments, the Senate's going to have the opportunity to make significant reforms to our nation's patent system for the first time in more than half a century. The America Invents Act is the product of extensive consideration. 4 Congresses we worked on this. We've had dozens of hearings, weeks of committee debate, and I've lost count of the hundreds of other meetings we've had. Now, this bill is an opportunity to show the American people that Democrats and Republicans can come together to enact meaningful legislation for the American people. The time to do that is now. The only remaining issues between saying the way this long overdue reform are 3 amendments. Each of them carries some merit. In the past, I might have supported them. But this is a compromise. No one senator can have everything he or she may want. The underlying issues have been debated. The bill as written represents a bipartisan, bicameral agreement that should be passed without changes. Any amendment to this bill risks killing it. Now, I'd urge all senators, Republicans and Democrats alike, to join me and join Senator Grassley in opposing these amendments. They're the final hurdles stand in the way of comprehensive patent reform. Now, I ask unanimous consent to include in the record letters from businesses and workers representing the spectrum of American industry and labor, urging the Senate to pass the American Invents Act without amendment. I ask unanimous consent for that.
Without objection.
The bill is important for our economy. It's important for job creation. It's a product of bipartisan and bicameral collaboration. It's the way our system is supposed to work. I look forward to passing the bill and sending it directly to the President's desk for his signature. And I know that my friends both in the Senate, on the Republican side and Democratic side have amendments to this bill. But they're not amendments that should pass. I mentioned the one earlier. I talked about the amendment that would put all our, well, Madam President, which amendment is the first in order?
Sessions Amendment number 600.
Madam President, I would yield the floor. I know that both Senator Sessions and Senator Grassley wish to speak to that.
Madam President.
Senators will have 4 minutes, evenly divided. Senator from Alabama.
Madam President, the oath that judges take is to do equal justice, and it says for the poor and the rich. Every day, statutes of limitations require that a litigant file a lawsuit within so many days, file petitions in so many days. See Senator Cornyn here, former justice on the Texas Supreme Court, Attorney General of Texas. He fully understands that. I know he supports my view of this issue, and that is that the rules have to be equally applied. And it's just not right that the little widow lady It's not right that somebody with a poor lawyer or whatever misses a deadline and a judge throws the case out. And they do. And big law firms like Wilmer Hale file motions every day to dismiss cases based on delay in filing those cases. Big insurance companies file lawsuits, file motions to dismiss every day against individuals while their claim too late. And they win. And so when this big one has a good bit of risk, presumably they have a good errors and omissions policy. That's what they're supposed to do. One reason they get paid this big bucks and the average partner makes $1 million plus a year is because they have high responsibilities. And they're required to meet those responsibilities and be responsible. So I believe it's improper for us, while this matter is on appeal and in litigation, for us to take action driven by this continual lobbying pressure that would exempt one company. And they can say it's others involved, but look, this has always about been one company. I've been here for 10 years. I know how it's played out. I've seen it. I've talked to the advocates on their behalf, and I just haven't been able to agree to it because I see the average person not getting the benefit they would give. So I urge my colleagues to join in support of this amendment. The Wall Street Journal and others have editorialized in favor of it, and I urge my colleagues to support it.
2 minutes.
2 minutes. Well, I think that the senator from Alabama has given me a reason to suggest the importance of the language of the bill that he wants to strike, because he said that law ought to be equally applied. Well, the law for this one company is that they were not given justice by bureaucrats that acted in an arbitrary and capricious manner, and they were denied their rights under the law. So that company is taken care of because there was an impartial judge that felt that they had been abused in their rights under Hatch-Waxman to be able to extend their patent. So you might be able to argue in other places around the country, when you're likewise denied your right, that you got this court case to back you up. But we can't have one agency saying when a 60-day period of time starts for mail coming in or mail going out to exercise your 60-day period, and for another agency to do it another way. And that's basically what the judge said, that Congress surely couldn't have meant that. So the language of this Section 37 does exactly what Senator Sessions wants, is to guarantee in the future that no bureaucrat can act in an arbitrary and capricious way when they decide when does a 60-day period of time start. And so we put it in the statute of the United States so the courts look at it and the bureaucrats look at it in exactly the same way. If you are a citizen of this country, you ought to know what your rights are. You ought to know that a bureaucrat treats you the same way they treat, in a like situation, somebody else. You can't have this sort of arbitrary and capricious action on the part of faceless bureaucrats that denies the rights. And this puts it in statute and solidifies it so everybody knows what the law is, rather than relying upon one judge or in the future having to rely upon the court someplace else. So I ask you to not support the Sessions Amendment because it would deny equal rights to some people in this country. As this judge said, those equal rights were already denied. I yield the floor.
The time's expired. Senator from Vermont.
President, I would ask consent that after the first vote, we have several more votes, that the remaining votes be 10-minute votes.
Is there objection? Without objection, so ordered.
And,
the question, the Senator from Vermont.
Have the ayes and nays been ordered on this?
They have not. The question is on the Sessions Amendment number 600.
And Cast the yeas and nays.
Is there a sufficient second?
Go up and down or table?
There appears to be. And the clerk will call the roll.
Mr. Akaka, Mr. Alexander, Ms. Ayotte, Mr. Barrasso, Mr. Baucus, Mr. Begich, Mr. Bennett, Mr. Bingaman, Mr. Blumenthal, Mr. Blunt, Mr. Bozeman, Mrs. Boxer, Mr. Brown of Massachusetts, Mr. Brown of Ohio, Mr. Burr, Ms. Cantwell, Mr. Cardin, Mr. Carper, Mr. Casey, Mr. Chambliss, Mr. Coates, Mr. Coburn, Mr. Cochran, Ms. Collins, Mr. Conrad, Mr. Coons, Mr. Corker, Mr. Cornyn, Mr. Crapo, Mr. Dement, Mr. Durbin, Mr. Enzi, Mrs. Feinstein, Mr. Franken, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Mrs. Hagan, Mr. Harkin, Mr. Hatch, Mr. Heller, Mr. Hoven, Mrs. Hutchison, Mr. Inhofe, Mr. Inouye, Mr. Isaacson, Mr. Johans, Mr. Johnson of Wisconsin, Mr. Johnson of South Dakota, Mr. Carey, Mr. Kirk, Ms. Klobuchar, Mr. Cole, Mr. Kyle, Ms. Landrieu, Mr. Lautenberg, Mr. Leahy, Mr. Lee, Mr. Levin, Mr. Lieberman, Mr. Lugar, Mr. Manchin, Mr. McCain, Mrs. McCaskill, Mr. McConnell, Mr. Menendez, Mr. Merkley, Ms. Mikulski, Mr. Moran, Ms. Murkowski, Mrs. Murray, Mr. Nelson of Nebraska, Mr. Nelson of Florida, Mr. Paul, Mr. Portman, Mr. Pryor, Mr. Reed of Rhode Island, Mr. Reed of Nevada, Mr. Risch, Mr. Roberts, Mr. Rockefeller, Mr. Rubio, Mr. Sanders, Mr. Schumer, Mr. Sessions, Mrs. Shaheen, Mr. Shelby, Ms. Snow, Ms. Stabenow, Mr. Tester, Mr. Thune, Mr. Toomey, Mr. Udall of Colorado, Mr. Udall of New Mexico, Mr. Vitter, Mr. Warner, Mr. Webb, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Senators voting in the affirmative: Cantwell, Cornyn, Hall, and Sessions. Senators voting in the negative: Begich, Brown of Massachusetts, Grassley, Klobuchar, and Leahy. Mr. Coons, no. Mr. Blunt, no. Mr. Warner. Mr. Warner, no. Mr. Johnson. Mr. Johnson of Wisconsin, aye. Mrs. Boxer. Mrs. Boxer, aye. Mrs. Feinstein. Mrs. Feinstein, no. Mr. Rubio. Mr. Rubio, aye. Mr. Kirk. Mr. Kirk, aye. Mrs. Murray. Mrs. Murray, no. Mr. Bingaman. Mr. Bingaman, no. Ms. Stabenow. Ms. Stabenow, aye. Mr. Roberts. Mr. Roberts, no. Mr. Udall. Mr. Udall of New Mexico, no. Mr. Menendez. Mr. Menendez, no. Ms. Ayotte. Ms. Ayotte, aye. Mr. Graham, no. Mrs. Hagan. Mrs. Hagan, no. Mr. Coburn. Mr. Coburn, aye. Mr. Vitter. Mr. Vitter, aye. Mr. Nelson. Mr. Nelson of Nebraska, no. Mr. Inouye. Mr. Inouye, no. Mr. McConnell. Mr. McConnell, aye. Mr. Tester. Mr. Tester, aye. Mr. Chambliss. Mr. Chambliss, aye. Mr. Isaacson. Mr. Isaacson, aye. Mr. Heller. Mr. Heller, aye. Mr. Lugar. Mr. Lugar, no. Mr. Lee. Mr. Lee, aye. Mr. Dement. Mr. Dement, aye. Mr. Pryor. Mr. Pryor, no. Mr. Franken. Mr. Franken, no. Mr. Kaka. Mr. Kaka, no. Mr. Crapo. Mr. Crapo, aye. Mr. Reed of Rhode Island. Mr. Reed of Rhode Island, no. Mr. Reed of Nevada. Mr. Reed of Nevada, no. Mrs. Murkowski. Ms. Murkowski, aye. Mrs. Gillibrand. Mrs. Gillibrand, no. Ms. Collins. Ms. Collins, no. Mr. Wicker. Mr. Wicker, aye. Mrs. Hutchison. Mrs. Hutchison, aye. Mrs. McCaskill. Mrs. McCaskill, aye. Mr. McCain. Mr. McCain, aye. Mr. Manchin, aye. Mr. Sanders. Mr. Sanders, no. Mr. Blumenthal. Mr. Blumenthal, no. Mr. Johans, aye. Ms. Mikulski. Ms. Mikulski, no. Mr. Risch. Mr. Risch, aye. Mr. Hatch. Mr. Hatch, no. Mr. Enzi. Mr. Enzi, aye. Mr. Cardin. Mr. Cardin, no. Mr. Lautenberg. Mr. Lautenberg, no. Mr. Johnson. Mr. Johnson of South Dakota, no. Mr. Nelson. Mr. Nelson of Florida, no. Mr. Barrasso. Mr. Barrasso, aye. Mr. Portman. Mr. Cochran. Mr. Cochran, no. Mr. Lieberman. Mr. Lieberman, no. Mr. Corker. Mr. Corker, aye. Mr. Burr, no. Mr. Alexander. Mr. Alexander, aye. Mr. Moran. Mr. Moran, aye. Bozeman. Mr. Bozeman, aye. Mr. Webb. Mr. Webb, no. Mr. Shelby. Mr. Shelby, aye. Mr. Hatch. Mr. Hatch, aye. Mr. Bennett. Mr. Bennett, no. Mr. Inhofe, aye. Ms. Snow. Ms. Snow, aye. Mr. Levin. Mr. Levin, no. Mr. Toomey, aye. Ms. Landrieu. Ms. Landrieu, no. Wyden. Mr. Wyden, no. Mr. Cole. Mr. Cole, no. Mr. Merkley. Mr. Merkley, no. Mr. Carper. Mr. Carper, no. Schumer. Mr. Schumer, no. Mr. Udall. Mr. Udall of Colorado, aye. Mr. Harkin. Mr. Harkin, aye. Mr. Carey. Mr. Carey, no. Mr. Whitehouse, no. Mr. Harkin. Mr. Harkin, no. Mr. Hoeven, aye. Mr. Portman, aye. Mr. Kyle, no. Mr. Brown of Ohio, no. Mrs. Shaheen, no. Mr. Conrad. Mr. Conrad, aye. Mr. Thune, aye. Mr. Casey. Mr. Casey, aye. Mr. Baucus. Mr. Baucus, aye. Mr. Durbin, aye.
Are there any senators in the chamber wishing to vote or to change their vote? On this vote, the yeas are 47, the nays are 51. The amendment is not agreed to. There are now, without objection, there are now 4 minutes equally divided prior to a vote in relation to the Cantwell Amendment.
Madam President.
Could we please have order in the chamber?
Madam President.
The senator from Washington is recognized.
Madam President, encouraging my colleagues to support the Cantwell Amendment. The Cantwell Amendment is reinstatement of Section 18 language as it passed the United States Senate. So casting a vote for the Cantwell Amendment will be consistent with language previously supported by each member. The reason we are trying to reinstate the Senate language is because the House language broadens a loophole that will allow for more confusion over patents that have already been issued. It will allow for the cancellation of patents already issued by the Patent Office, throwing into disarray and legal battling many companies who already believe they have a legitimate patent. The House language, by adding the words other, broadens the definition of Section 18 and extends it for 8 years, so that this chaos and disarray that is really supposedly targeted at a single earmark for the banking industry to try to get out of paying royalties is now so broadened that many other technology companies will be affected.
Can we please have order in the chamber to allow the senator to finish her remarks?
I urge my colleagues to support the Cantwell Amendment and agree to the language that you previously agreed to.
Thank you. The senator from New York is recognized.
I rise in opposition to my dear friend Maria Cantwell's amendment. Business method patents are a real problem. They never should have been patented to begin with. Let me give you an example. Double-click. We double-click on a computer or something like that, and after that's a practice for a while, someone files a patent and says, I want to patent double-clicking. And because of the way the Patent Office works, the opponents of that never get a chance to weigh in as to whether it should be a patent. And the Patent Office has gone way overboard in allowing these business method patents. Now, you might say, well, then you get your day in court. Well, that's true, except 56%, more than half of all the business method patent litigation goes to one district, the Eastern District of Texas, which is known to be extremely favorable to the plaintiffs. It takes about 10 years to litigate. It costs tens of millions of dollars. So the people who are sued over and over again for things like double-clicking and things like how to photograph a check, common things that are business methods and not patents, settle. And it's a lucrative business for a small number of people, but it's wrong. What this bill does is very simple. What the bill does in terms of this amendment is very simple. It says the Patent Office will make an administrative determination before the years of litigation as to whether this patent is a legitimate patent. And that doesn't allow the kind of abuse that we have seen. It applies to all financial transactions, whether it be a bank or Amazon or a store or anybody else, and it makes eminent sense. So as much respect as I have for my colleague from Washington, I must strongly disagree with her argument and urge that the amendment be voted down and yield back the balance of my time.
The question is on the amendment. Is there a sufficient second? There appears to be. The clerk will call the roll.
Mr. Akaka. Mr. Alexander. Ms. Ayotte. Mr. Barrasso. Mr. Baucus. Mr. Begich. Mr. Bennett. Mr. Bingaman. Mr. Blumenthal. Mr. Blunt. Mr. Bozeman. Mrs. Boxer. Mr. Brown of Massachusetts. Mr. Brown of Ohio. Mr. Burr. Ms. Cantwell. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Chambliss. Mr. Coates. Mr. Coburn. Mr. Cochran, Ms. Collins, Mr. Conrad, Mr. Coons. Mr. Corker, Mr. Cornyn, Mr. Crapo, Mr. Dement, Mr. Durbin, Mr. Enzi, Mrs. Feinstein, Mr. Franken, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Mrs. Hagan, Mr. Harkin, Mr. Hatch, Mr. Heller, Mr. Hoven, Mrs. Hutchison, Mr. Inhofe, Mr. Inouye, Mr. Isaacson, Mr. Johans, Mr. Johnson of Wisconsin, Mr. Johnson of South Dakota, Mr. Kerry, Mr. Kirk, Ms. Klobuchar, Mr. Cole, Mr. Kyle, Ms. Landrieu, Mr. Lautenberg, Mr. Leahy, Mr. Lee, Mr. Levin, Mr. Lieberman, Mr. Lugar, Mr. Manchin, Mr. McCain, Mrs. McCaskill, Mr. McConnell, Mr. Menendez, Mr. Merkley, Ms. Mikulski, Mr. Moran, Ms. Murkowski, Mrs. Murray, Mr. Nelson of Nebraska, Mr. Nelson of Florida, Mr. Paul, Mr. Portman, Mr. Pryor, Mr. Reed of Rhode Island, Mr. Reed of Nevada, Mr. Risch, Mr. Roberts, Mr. Rockefeller, Mr. Rubio, Mr. Sanders, Mr. Schumer, Mr. Sessions, Mrs. Shaheen, Mr. Shelby, Ms. Snow, Ms. Stabenow, Mr. Tester, Mr. Thune, Mr. Toomey, Mr. Udall of Colorado, Mr. Udall of New Mexico, Mr. Ritter, Mr. Warner, Mr. Webb, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Senators voting in the affirmative: Boxer, Cantwell, Coburn, Dement, Johnson of Wisconsin, Murray, Sessions, Udall of Colorado, Vitter. Senators voting in the negative: Akaka, Ayotte, Barrasso, Baucus, Begich, Bennett, Blumenthal, Blunt, Bozeman, Brown of Massachusetts, Burr, Cardin, Carper, Casey, Chambliss, Coates, Cochran, Collins, Conrad, Corker, Cornyn, Durbin, Enzi, Feinstein, Franken, Gillibrand, Graham, Grassley, Hagan, Harkin, Hutchison, Inhofe, Inouye, Isaacson, Johans, Johnson of South Dakota, Kirk, Klobuchar, Cole, Landrieu, Lautenberg, Leahy, Levin, Lugar, Manchin, McConnell, Merkley, Mikulski, Moran, Nelson of Nebraska, Nelson of Florida, Portman, Reed of Rhode Island, Reed of Nevada, Risch, Roberts, Rubio, Sanders, Schumer, Shaheen, Snow, Stabenow, Tester, Thune, Toomey, Warner, Whitehouse. Mr. Shelby, no. Mrs. McCaskill, aye. Mr. Crapo, no. Mr. Heller, no. Mr. Menendez, no. Mr. Pryor, aye. Mr. Wicker, no. Mr. Hoven, no. Mr. Brown of Ohio, no. Mr. Lee, aye. Mr. Kyle, no. Mr. Wyden, no. Mr. Udall of New Mexico, no. Mr. Alexander, no. Mr. McCain, no. Mr. Bingaman, no. Mr. Lieberman, no. Mr. Webb, no. Ms. Murkowski, no. Mr. Hatch, aye. Mr. Carey, no. Mr. Coons. Mr. Coons, no.
Okay. Are there any senators who wish to vote or to change their vote? On this vote, the yeas are 13, the nays are 85, and 1 senator responded present. The amendment is not agreed to. There are now 4 minutes equally divided prior to the vote in relation to the Coburn Amendment.
Madam President.
The senator from Oklahoma is, could we please have order before the senator from Oklahoma speaks? The senator from Oklahoma is recognized.
Thank you.